I want to kind of get in for all the listeners to the FCRA tonight. Let Larry go in, and then I'll give you my sick plan that I've discussed with about, a couple hundred attorneys over the last 3 years that are all into the foreclosure defense. And they all suggest it's pretty ingenious. The problem is nobody puts it to work. And I heard you guys chitter-chatting earlier about how these attorneys will let you out cheap, man. And it's a fact. They'll throw you under the bus. I've seen that happen over and over. But using the FCRA and the FDCPA, and I'll go into those details once Larry explains a little bit more about the FCRA tonight and how you can use it to make yourself a few $1,000 quickly, which is always a great thing. But I'll use it. I'll show you how you can use it into foreclosure too, and preferably you want to use it in the foreclosure in the obviously pre-foreclosure stages, but you can use it after the fact. I mean, it's not going to help you much during, but it will help you pre and post. So with that being said, I'm going to let the call go over to Larry, and then go ahead and show him some of your tips and tricks, Larry, on the SDR how to make some bucks pretty quick like you did on your webinar.
Gotcha. Jeff, do you want to do any kind of an introduction, or should I jump right in?
Well, I think that Jesse just basically handled the whole thing for me.
Well, there you go. I mean, it's almost like you're not needed.
Really. Yeah, well, Larry is one of the key players in our effort to supply you with the information and knowledge in order to fend off debt collectors, be they credit card debt collectors, be they foreclosure debt collectors. It doesn't really much matter what form they take or what their source is. If they're a third-party debt collector, they're available for our shots. And we do give them some broadsides that really hurt. And the FCRA is one that is the amount builds up very, very quickly. So with that, Larry, do you want to talk about the FCRA?
Sure, and I should say, just to clarify, it hurts them. It feels really good for us.
Yes. Oh,
yeah, okay.
I guess I did leave that little detail out.
Yeah, absolutely. Yeah, I'll talk about a little bit about FCRA in a few minutes. First, I just want to give a brief introduction. Jesse's on the line now, and our other partner, John, I don't know if he's coming online. Sometimes we switch in and out on these calls. Oh, you are? Okay, good. All right, so you can chime in whenever you want to talk about your stuff. Anyway, we each have our kind of specialties. John concentrates on protection and dealing with liens and levies and making sure that nobody's taking your money. Jesse's main specialty is handling foreclosures and defending against them, and ultimately keeping your property. He's been quite successful in having people just hold on to their property for year after year, and we're actually working on some strategies that will allow you to, get rid of these attorneys and mortgage servicers completely. And, when the time is right, we'll certainly give that information out. My main specialty is working with, as Jesse and Jeff said, the FCRA, which is the Fair Credit Reporting Act, Fair Debt Collection Practices Act. We've incorporated the Telephone Consumer Protection Act, and basically what we're all about is for people to take action. And whatever situation they're in, there are all kinds of ways that you can deal with it. Our favorite, at least my favorite, is suing collection agencies, suing credit bureaus, suing attorneys, and taking money from them and putting a stop to whatever they're trying to take from you. How I got started, and this is probably about 8 years ago, I ran through some financial difficulties for a while. And so I had collection agencies suing me. And I did my due diligence, and I did some research, and I figured out how to beat them. And I got sued 3 times, and all those cases were dismissed. I've never lost against a collection agency. And I decided, and for the most part, I could prove that I didn't owe money to any of these people. And I decided, I'm not going to be a victim anymore. I'm going to go back after them. And I started suing, primarily in federal court. And defendant after defendant would either pay me money in settlements or I would get judgments against them. And I don't know exactly how much I've taken. It's probably somewhere in the range of $75,000 or $80,000 as of right now. And I haven't gone anywhere near, what I could be collecting. So I'm still at it. I've gotten $10,000 judgment from Capital One, $5,000 from Calvary, and it goes on and on like that. So what we've been working on, and I've come on relatively recently, probably in the last 8 or 10 months, but Jesse's been working on, and John has been working on this for over a year. We put together a website that gives out information and everything that I just talked about, and our goal is to reach as many people as possible, and we want to do it at a very reasonable rate. We don't want to charge $3,000, $5,000, $10,000 and give people mixed results. We want to give all the information that we have and constantly update it, and we do webinars, we do forums, this, that, and the other thing. And we want people to take action. We want people to learn what we've learned and go after these bad guys. So, and one of the things, as Jeff and Jesse were saying, Fair Credit Reporting Act is one of the best ways that we've found to do that. And I'm not sure exactly. I think I know what strategy Jesse is talking about. He can let us know in a few minutes. But Fair Credit Reporting Act is an extremely powerful federal law because once you start disputing inaccurate items on your credit bureau, and I'm sure a lot of you already know this, then all kinds of people can be violating the FCRA. It can be the credit bureaus, it can be the furnishers of information, collection agencies, mortgage servicers. It can be anybody who's pulling your credit without what's called a permissible purpose. And that's actually maybe the easiest way we found to get money from these people who are victimizing you, in effect. So if somebody is pulling your credit report and they don't have the authority to do that under FCRA, then basically they owe you $1,000 every time they do that. And whether or not you actually have to go to federal court or you can simply threaten to sue them, and we certainly encourage people, if you don't have to go to court, don't go to court, because sometimes all you need to do is send a notice of intent to sue, and when they realize that you're serious and that they're going to be paying an attorney $5,000, $10,000, $15,000, $20,000 to defend themselves, then they're going to be in a position where, generally speaking, they're going to want to settle with you and pay you what the law allows. So, as I said before, we also incorporate Fair Debt Collection Practices Act, which in certain instances is extremely powerful, particularly in cases where you're dealing with foreclosure and you have actual damages or potential actual damages, because the FDCPA allows for that. So one of the things I really like to do is sue attorneys and sue law firms, because I can guarantee you if you've been sued for any kind of debt collection, or if you've even been contacted by an attorney, then they're going to be in violation of FDCPA, and they are ripe for a federal lawsuit. And it's very straightforward to file and pursue a federal lawsuit. You almost never have to actually appear in court in federal, and it's a very step-by-step process. And again, your goal is settlement. And if you've got something negative on your credit report, you want to get that off. If they're coming after you for an alleged credit card or mortgage debt, then you're going to want to make them stop. So again, what we like to do is combine all of these strategies, just depending on an individual's particular situation, and we provide just reams of information that people can look at and utilize to whatever their particular needs are. So that's basic.
Larry, you might want to expand on the form that comes in, because it's not just people have to sit there and read.
Right. Well, I talked about the webinars. So we do webinars once a week on Wednesday at 3 p.m. and anybody who's a member can come in on those webinars. Up until a few weeks ago, each of us were doing one webinar a week, and we realized that the information was just way too much for everybody, because we're talking about an hour webinar each time, and for somebody to come in 3 times a week and soak in all that information, just based on our experience and our research on the law, it just proved to be too much. So what we're doing now is alternating. Each of us are doing one webinar every 3 weeks. So Wednesday at 3 o'clock is when it happens. Tomorrow I'm doing one, and then actually what I'm focusing on tomorrow is case studies. So if anyone's a member, I really want you to come in on that webinar, either through email or through the webinar itself online, or to call in and tell us what your situation is, and good things, bad things that have happened, where you are in the process, any potential roadblocks that you're facing, and let's talk about it and see if we can work through it. And if you have successes, then we want to hear about that too.
Right, and when you have your webinars, there's almost invariably a document of some sort put up on the screen that you're going through.
Yeah, I tend to do less of the documents. I know Jesse does a lot, and I think John does too. Just depending on what particular webinar we're dealing with. And all these webinars, by the way, are in the archives. So you can go back, and they're, they have titles, so you can pretty well determine what each of these are covering. And if you see something, as a member that you think is going to be useful to you, then pop up that webinar and go through it and get all the information that you need. And our webmaster has determined that lots of people are looking at the same webinar 2, 3, 4 times because, again, there's just so much information there. And I guess, and I certainly hope, that they're getting what they need and actually utilizing it. And we're starting to get some success stories, and that's what we're all about. We're tired of people who are sitting back, and I'm sure all of us have been guilty of this at certain times and just in effect being victimized. But we're all about providing the information and getting people to take action and reclaim their rights. And these are federal and state laws that are there to protect you, and we want them. We want people to use them. And not just a handful of people. We want people all over the country, thousands of people, using this stuff and protecting themselves and taking money from the bad guys, as I like to say.
Making them sit up and pay notice.
Exactly.
And you go in there and vindicate your rights. So am I to conclude from your tone of voice there, Larry, that you want to go ahead and open up for questions?
Yeah, unless Jesse or John want to say anything at this point.
Well, I want to chime in. I'm almost done here. You did a good job, Larry. Thanks. We got to explain more, I think, and maybe not. You guys let me know. To the callers on the goal of the site and the reason it was even formed. Obviously, I've been doing a lot of foreclosure defense for years, as a lot of these listeners have. And I always knew that you're better off always on the offensive than the defensive. And as a matter of fact, John found that out today in his federal case, just one little incident. And he takes charge. He tells 7 attorneys or 8 attorneys what to do, and they do it. It's that simple. And that's the beauty of this whole deal. But the goal of the site was obviously multi-level, meaning something that's effective, number one, that we know works, and it works 100% of the time. Number two, it was cheap. Everybody can afford it. I don't care if you're broke. If you cannot scrounge up $100, there's nobody going to help you on this plan. So it's got to be cheap. But the icing on the cake was, where else do you ever go find a product or a system out there that not only is it cheap to get into, you get 100% results, and you get paid back from it? That's the three things that I had personally in mind. And I've been talking about what I mentioned earlier with the FCRA, the FDCPA, and particularly Florida, the FCCPA. And the challenge, and I'm doing it right now. So once again, I'm always the guinea pig. Like Larry, I've never lost a single foreclosure case yet. 532 active foreclosure clients as we speak that I'm helping, and we're kind of teaching and sharing information together, and everybody's still in their house, and some of them go back years. We're reaching a statute of limitations here in Florida for these people, so obviously we're going to be able to just get the home free and clear. It'll be a done deal. John pretty much sealed his fate today. His house is free and clear through the Fed court. There's just no ifs, ands, or buts about it unless he really screws up somehow, which he won't because Larry and I won't let him. He's pretty much done deal. So there's ways, but what I was going to say, Larry, about the FCRA is what I did is I did a dispute with the credit bureaus. I did 3 of them way back August of last year, August, September, and October. And the reason I did that, and the students that we have and that are members actually on this call, if you guys recall, my very first homework assignment for everybody was to go out to the public records and find their assignments, if there is one. And, of course, if you found one, you need to look for the fraud, et cetera, but just to go look for an assignment. And the results are about 95, 96, 97%, it's up there, of the people that actually went out and looked, found nothing. Okay? So we got a situation here. Obviously, with the TILA change and mod that they did in 2009, that's a whole different animal, but say it was prior to that. I went ahead and disputed with them. I said, listen, I don't know who Century Mortgage is. Never had done any business with these. I'm sorry, not Century, Carrington. I said, I don't know who they are. They're on my credit report. They've been reporting, and I have no business with these people. So they come back. They verified. Oh, yeah, they verified. Okay, fantastic. So I'm waiting because what's happened is on this particular foreclosure case, I'm about 7 or 9 months, and I'll walk out free and clear. So I don't want to disturb something that's laying quiet, but I already have all the ammunition ready to go. And what I intended to do was use the FCRA in conjunction with the FDCPA, and I'll leave it at that. Don't worry about the Florida, because any Florida or any other state act is a mirror image, so it's just going to be a double charge in essence. You can't violate one without the other. It's impossible. You do it at the same time. So if I challenge Carrington Mortgage and the credit report is reflecting the negative and the derogatory information, and the credit bureaus themselves said to me, oh, no, we verified. So I disputed it again, which I don't have to, by the way. Nobody has to. All you got to do is dispute it once. But I disputed it again. I said, listen, I think you're wrong. All right? I said, here's an actual copy, first page of my mortgage and the note. It doesn't say Carrington anywhere on there. Here's the property address that coincides with the credit report. I mean, I really did some detailed work. Larry, you remember this.
Yeah, I sure do.
I sent it to them. They come back and say, well, we verified it. It's verified. Okay, fantastic. Obviously, you cannot read. And the reason I did that is if I sue in the federal court, which I will if I have to on this particular property, they're going to have to prove to the court, and this is Carrington Mortgage, and who's suing me, by the way, is Deutsche Bank. But Carrington's there, so they would be one of the defendants. They're going to prove to the court that they have the right to report this derogatory information. They're going to have to prove the right that they had the right to collect payments. They're going to have to prove the right that they had to put fourth-place insurance on that property. And then they're going to have to show a connection from ABC Mortgage Company, which it was New Century, to Carrington, to Deutsche Bank. And there ain't nobody getting out of that in the federal court. It's not happening. Okay, Jeff, you just sent me a decision with MERS. It just came out in California. It came out the 11th. And I just briefly read through it, but that's your perfect case in point. All these wonderful decisions are coming out of federal courts. They're never coming out of circuit courts. You never hear it coming out of these circuit courts. So the circuit court judges are a bunch of crooked yahoos. Everybody knows that. So you can use the FCRA, and in the end, you're going to sue, at least I recommend, between us, Larry, myself, and John, what our intentions are, I want to sue the credit bureaus. And when you ask for discovery, when you get into the discovery phases, you're going to ask the credit bureau, how did you verify this with Carrington Mortgage? And I'm going to ask Carrington Mortgage how they verified it to the credit bureau. See, separately. I want to see how these answers work together, because they're going to have to show us, and how does Deutsche Bank come into this whole thing? Which we know they're trustee and they don't have the power to foreclose, et cetera, and that's all on the website under the service and pooling agreement. But my point is that once you do that and you allege the same thing under the FDCPA is trying to collect an alleged debt with the false amounts or incorrect amounts, the legal status of the debt, et cetera, you got these guys cornered. You got them literally cornered. What's happened, though, over the last 2 years is through this Patriot movement, and certain people, I'm not going to mention, everybody knows who they are, they're selling these $3,000 and $5,000, now $7,000 and $8,000 gimmicks, which I say for nothing, because you don't need any of that. 90% of stuff doesn't work. 95% of stuff doesn't work, and it's especially not going to work because it's so complicated that none of us understand it. But the FDCPA is very simple. The FCRA is very simple. The TCPA is very simple. And your state acts, once again, I don't even like to talk about them because they're just a mirror image of the FDCPA for the most part. Would you agree, Larry?
Yeah, what I've seen, certainly. I mean, the Florida...
Yeah, there's not much difference there. So it's using those in combination that's really going to kick them in the nuts. And that's the simplicity of it. I've been saying it for weeks, guys. The beauty of the FDCPA is just unbelievable, and it's so simple to use. And I'll give you an example. One of our students is getting sued by Capital One again. Well, he just filed a countersuit today against him. That's it. $2,000 debt. You're going to pay an attorney $5,000 to defend it. Make up your mind. How do you want to handle this? You want the debt to go away? See, he'd be happy if the debt just went away. He doesn't care. He says, if I can just make it go away, get it off my credit report, I'm a happy dude. So to solve his problem, so any logical attorney is going to say, damn, I'm going to defend this because the counterclaim, the guy who was sued in small claims, the counterclaim is for the state act in the small claims under the FDCPA, and he filed in the federal court with the FDCPA and FCRA. Not only did he file there against Capital One, he filed there against the attorney's firm and the attorney individually. So who's going to shell out $15,000 to go defend all this crap over a $2,000 alleged debt? That's the point. That's the strength of this. I got a friend of mine in Georgia, same thing. I'm going to help him wrap this up. He's a very good friend. He's been in his house, I don't know, 3 years now. And I'm trying to get to the statute of limitations, same thing. And this time we're hammering an attorney. So he's doing the TRO, which he already has. He's already done. We could have got summary judgment last time. The damn judge was crooked. It should have been ours against the bank. It would have shut him down completely. But we'll get the TRO, and then within 2 weeks, he's going to file in the federal court and sue the trustee, the substitute trustee, MERS, Bank of America, Countrywide, everybody. Anybody who's touched it, his name is on that assignment, anybody is going to get hammered. And we're going to see how quickly that stops that foreclosure in 2 seconds till all this is handled. So these are the things that I'm talking about that our system will provide for you, that simplicity will win over complexity every time. And none of this stuff is complex. So you get ways to make money. Obviously, you got John, and John is the king of, put it this way, using John's system, you can just lead all these people, let them get their judgments, let them get whatever they want. They can never touch your money anyway because you're broke, according to him, once you implement the system. So there's many ways this can account, but our goal is to help people actually fight back, put these debt collectors out of business, put these servicers, which we're not going to put them out of business because if they're short on money, they just rip us taxpayers off and bail them out. But you're going to hammer them long enough or it's just going to get too pricey for them. You're going to overburden the judicial system enough to where the judges are just going to say enough's enough. And for you Florida people, throughout this call, I don't know if you heard a couple weeks ago, the Orange County Courthouse almost shut down. Larry, you told me they got an extension Friday up till June 30th, I think you did, $50 million for 2 months. A ridiculous amount of money that the governor didn't really want to give, but did at the last minute. And the excuse was the foreclosure filings have slowed down a bit. So it almost shut them down. Well, you're telling me you're counting on people losing their homes and the court ripping people off and throwing them out of their homes so you can stay in business? Really? How'd you run the courthouse for the last 50 years without that? What they're not saying is, if you go on Dun & Bradstreet and you look up your local courthouse, it's a corporation. You go look at their investments because they have to be public. They're there. Our particular courthouse there has like $7.2 billion had in mortgage-backed securities. They took up over 80% of their portfolio. Well, between that and these retirements, it's disappearing faster than the value on people's homes. So everybody's scrambling right now in these municipal corporations. Don't forget that. So just keep an eye on your local stuff. California's already paid with IOUs, if I'm not mistaken. So it's getting ugly out there. The more pressure we can keep on them, the better off we are. So I'll finish with saying, if you have people that you know are in trouble and you are a member, do the right thing, you have the resources, help them out. Help them out. Don't just think about yourself. Help them out and get them resolved. Don't charge them any money. You already have the resources. God's blessed you with enough money to be able to pay that $100. You get out there and you help those people that need it so they can become members, and then they can start making a few bucks on it.
Well, Jesse.
Sorry, I dropped the phone.
Don't forget about the freebie that's on the front page of the website that you don't have to be a member to use.
Yeah, we give so much free away, and I said this on the call Saturday night radio show that we were invited to. What we give away on the front of our site, and I don't want to talk about the website's name. You all know how you get there. You guys got the emails. At the end of the day, what we get for free, people are charging $1,500 to $5,000 for. As a matter of fact, Larry has a webinar that once you opt in and you download the PDFs that have PROs, motions for enlargement of times, motions to dismiss, there's examples of everything in there. Larry's got a template or a webinar that he's actually helped upload that will allow you, and it shows you how he's made thousands of dollars by using the credit report. And he just named it how to make the quick $1,000 in the next 30 days because it's very, very much that simple.
I think you'll find that that's a sample. Right, Jesse, that's a sample?
I'm sorry?
That's a sample?
Yeah, he's got several. We got several samples on there.
Okay.
And Larry's shown he's got sample after sample on the webinar on how he's made, thousands of dollars by just sending out notices of intent to sue. I think he had 36 defendants. I had 35. Yeah, on one suit, by the way. On, I think it was a 3-month period, Larry, you hammered $35,000.
Yeah.
Something like that from these guys. And this was just strictly FCRA, just for credit report stuff.
No, it was more than FCRA, but it was also including FDCPA. But, the bulk of the money probably came from FCRA. Yeah, I settled with 13 out of 36 defendants over the course of a few months, and like I just said, took $35,000 from them.
So, guys, it works, but if you don't use it, it's not going to work. It's like anything else, So, with that being said, I'm more than welcome everybody to get in there. I think it's *6 to raise your hand.
It is *6 to raise your hand.
Yeah, get in there, start asking questions, and because I really do want to wrap this call tonight up at around 9:15 at the latest. So it is. We got over half an hour, 50 minutes for questions. So make them quick, short, not 5-part questions, etc. Just get to the point. Let's get it hammered out.
Okay. Bob, you're up.
Hey, how you doing, guys?
Hey, Bob, how are you, buddy?
All right. I've been listening to you guys for a little while now, off and on. My question for you is, I've got a attorney filed lien against my credit report. I guess we'll call it it's not a lien, it's a judgment. I'm sorry. And I'm curious. It had to do with a real estate matter. He did some work for me on, but he did a very poor job and charged me as much as he could. At that point, this is going back about 4 years ago, I did not know how to fight that, so he got a judgment against me. It's in New Jersey, which is a judicial state, and I want to know how I can go after him to get him to get that off and possibly get him for some violations of the what we guys been talking about.
Yeah, let me ask you some quick questions. Is he actively trying to collect this alleged debt?
No, he's not.
Okay. Have you contacted him any time in the last few years?
No, I haven't.
Okay. Have you disputed with the credit bureaus? Is it showing up on your credit reports?
Just did last month, about over 31 days ago.
Okay. And have you gone to the public records, whatever office it is that has that alleged lien?
No, I have not.
Okay. The first thing, a couple of things I would suggest right off the bat, and Jesse and John may have some other ideas too. Go down to the public records and see what's actually there, and make a copy of it if you don't already have one, because you want to know what you're dealing with exactly. The next thing I would definitely do is dispute with the credit bureaus. What is your goal here? Because if he's not actively collecting, then at some point, I'm assuming this lien is going to expire.
Right. I want to clean up my credit this year. I want to
Okay.
I want to go after about 5 or 6 entities that are on there that they're keeping it pretty low.
Okay.
In regards to the credit score.
Yeah. So definitely the first thing you need to do is dispute with all 3 credit bureaus, and then see what happens. and that's really one of the main things that we recommend. And there are templates and letters and everything else on the website as to exactly what steps you need to do to handle that. At some point, whenever you're ready, depending on what happens, because if you're disputing these, and unless they can absolutely prove that every bit of information they're reporting is accurate, and even then, they need to report that lien as being in dispute, and if they don't, then you have an opportunity to sue them. So
I noticed one thing on my credit file was that they had reported that debt twice, it was almost the same amount of debt, but it's only one, should only be one debt, not two, of the same category.
Okay. To me, Larry.
Go ahead.
To the same attorney?
Yes.
Yeah, same debt.
Same
They're reporting it twice.
Yes.
Okay. All right. Well, that's a violation both of Fair Credit Reporting Act and Fair Debt Collection Practices Act. But you got to dispute with the credit bureaus. That is absolutely essential.
I did that. I guess I'm still waiting on their decision on that. I haven't seen anything in the mail yet, nor have I seen it on my credit file. So it's around I believe it's around 30 days. I look on my notes. And I don't want to take up too much time here. I have one other question, and I'm trying to make it here quick. When you said statute of limitations in regards to real estate matters, in regards to foreclosure, could you just give me a brief, very quick synopsis of what you're talking about there in regards to being able to keep your house, I guess Jesse said, free and clear if you reach this, past the statute of limitations on them?
Yeah, Florida, it's 5 years and 1 day from the last day of activity on the account.
Judicially speak, in the courts, correct?
No, on the last activity on the account, meaning the last payment I made.
So, just bear with me here 2 seconds. So if you made a payment on your mortgage 5 years and 1 day ago, technically they can't do anything to you at that point because they haven't foreclosed on you.
Correct.
Okay, I got to look at that. I got to look that up. I got to look
at
that.
There's like a 3-day window that you got to give them. Then you do a dispositive motion to close it out and be done with it.
And you're doing that in federal district court?
You're doing that even in the county court, state court, circuit court, doesn't matter. Wherever your case happens to be. Once that expires, it's over. And then you move in for your quiet title and be done with it.
And I could find, where would I look for that in New Jersey law? Just Google it or?
Statute of limitations?
Yeah, thanks, Jeff. Okay.
Send me an email. I'll get it for you, Bob.
Thank you very much, Jeff.
You're welcome.
All right, guys, I know there's other people on there, so thanks, man. I really appreciate it. I'm going to be diving more into this.
Yeah, man.
Okay. Our next caller is evidently calling in from their work phone, so I don't know who they are, but they're calling from Washington, D.C.
It's actually a mobile phone.
Oh, Mike?
Yes, sir.
It only just says Institute 4, and no further.
Yeah, there you go.
It didn't
yeah, it is a work phone. That's right. Yeah. Sorry about that.
It's okay.
Probably call from my. Yeah. So, real quickly, in the interest of time, if we were thinking of selling our home, or let's say even have already sold our home, could we're not in any kind of foreclosure problems, could we still use the techniques that you all promote in terms of like a qualified written request saying, prove up the fact that we owed you, we had to pay you anything at any time? Could we still do that, or once it's sold, that's it, you're out of commission?
If it's on your credit report, you have time, you can do it. Basically, as long as you don't run out of your statute of limitations, you're good to go.
Yeah, and my recollection of RESPA, the Real Estate Settlement Practices Act, is you have 1 year to bring an action. So, and don't quote me because it's been a while since I've looked at this, but I think you can send the mortgage servicer a letter, and they've got to respond within 20 days, and then answer or fix the problems within 60 days. But I'm pretty sure that you've got a 1 year statute of limitations on that.
So is all of this true even though we're not in foreclosure, we're not behind on our payments, and there's nothing on our credit report?
Oh, absolutely.
Yeah,
Real Estate Settlement Practices Act, if you send a qualified written request, it doesn't matter if you're in foreclosure. You have a right to certain information about the mortgage, the payments, and they've got to respond. And if they don't, then they're in violation of federal law.
So digging in a little deeper on the QWR, am I correct that you would generally, if not always, want to send the QWR before any kind of a notice of intent to sue? Is that fair to say?
Oh, yeah, I would. I'd be hard-pressed to think of a situation where you wouldn't do that unless it's an emergency. You definitely want to send the QWR.
So that having been said, simply by virtue of the fact that we have a MERS rider and the fact that we're not behind on our payments, we're not in foreclosure, there's nothing on a credit report, I guess I'm hung up about the best format or the best approach with regards to the QWR. any absolute do's or don'ts with respect to sending that out, because I just kind of feel like once I send it out, that's a one-shot deal. Maybe, I don't know. Maybe I'm not looking at it the right way. But.
No, generally speaking, yeah, they're not going to respond very effectively to the QWR. I mean, Jesse, I don't know how you feel. It's probably 80 or 90% of the time they're not going to answer your questions, or they're not going to answer them honestly or accurately.
But even
what do you think?
More than that, interject for just a second, Mike. What I tell everybody on the site, all our members and then all the listeners, and our fan base is growing, if you want to call it a fan base, which is great because to us it's motivating us, obviously, to do what we need to do, is I love people that are not in foreclosure. I love people that have perfect credit. I love people that are working their jobs and can afford or have their business and can afford these payments, because that's where the fun really begins. All right? The people who come to us and say they're going to sell my house in a week are the ones you can't really help. Okay? The guys like yourself are the ones that you set up, and you set these people up for a fall, and a big one. That is the beauty of the system. You could have an 850 credit score, and then we're going to bring it up to 890 without doing anything, and you'll probably get paid to do it too. So you clean up your credit at the same time. And you forgot, or you didn't hear, or you weren't on the call, at the beginning of the call I said something, and I said this to all our students. When we launched, we only launched the site January 19th. So we're not even in our, 90-day, we're about 75, 80 days out. The beauty of the system is you need to go out to the public records and find who, if, and when it was ever assigned. Because your qualified written request you're sending to the servicer, and that's what everybody does. And that's not who I'm sending this to. I want to know, I'm sending the qualified written request to the lender that's on my mortgage, because I'm in dispute now with this guy over here going, why am I sending you payments when I have not received the goodbye letter or the hello letter, which is a conditions precedent on both the mortgage and the note, every time they change? Because if you read Section 20 of your mortgage, Mike, it's very clear. And it tells you that the note along with the mortgage can be sold one or more times, and that would include and not include a change in servicers. And they have to notify you. That's a conditions precedent that kills them in foreclosure. And I have a webinar we did on that, which is archived, and I showed all the orders, one after the other, where these judges are saying it's a contractual condition precedent, so they didn't have the right to foreclose. And they reversed and remanded all. You're looking at a starting spot. The starting spot is public records. Public records is going to dictate to you where you go. It's either left or right at that point. You see? Because if your mortgage, first of all, I have a house in Tampa that's not a MERS mortgage, yet MERS did an assignment. What the hell is that about? It's not even a MERS mortgage. It's nowhere on the mortgage.
So are you saying that I should send my
to the first original person who is on my actual mortgage right now? If I get no response, I am going to get that and put it away. Then I'm going to send it out again. Hey, the second request, et cetera, to them. I'm not sending it out to that servicer. But at the same time, that servicer, I'm going to send them out a letter, and I'm going to ask them, how and when did you acquire the rights to collect my money? Please send me some kind of letter that you had sent me. Don't send me some blank letter. I want a letter that was signed or by somebody or something that said, hey, listen, hey, we're ABC Mortgage Company, and we've now are authorized to take your payments, and I'd like to see if your first original lender, pretender lender's in business, and they answer you is, where's the goodbye letter? Hey, we've transferred the rights to so-and-so. Oh, and by the way, if you continue reading Section 20, it says that this note can be sold one or more times without prior notice. Understand the word prior. Means I can sell it and then tell you. I'm not going to tell you. I don't have to tell you. It says I'm going to sell it, then I have to tell you. That's exactly what those words mean. You follow me? So the original lender, hey, when and to whom did you sell this to? Now that's a good question, and you're entitled to know because it's right on your contract. So when you go after them, you make the call, but it all starts right there at public records. And even if you sold the home, it's the same thing. You want to call them and say, yeah, hey, why did you collect these payments, and who gave you the authority to collect these payments?
Wow.
You see, there's all kinds ways to skin a cat, but you're in a good position to do it. And strategic foreclosures are the best ones. All mine were
that's
strategic.
really what I'm aiming to do. Sorry, go ahead.
Yeah,
that's what I'm aiming to do.
So let me just clarify one thing you said, and you said send the QWR letter to the to the lender, and really that's kind of shorthand because whoever claims to be the lender almost never is. They're really a servicer of some kind, and a QWR is sent to a servicer, but I'm going to assume that anybody who's touched the mortgage in any way is a servicer and not the lender, and that's probably true 98, 99% of the time, unless you're maybe dealing with a credit union or something like that. So, yeah, and if they claim to be the lender, then they can tell you that. But you're going to be in good shape if you send a letter, as Jesse described, and see what happens. There's almost no downside that I can think of to sending such a letter.
And so at what point do you make I'm sorry if I'm dominating this here real quick, but just at what point do you then send the notice of intent to sue? I mean,
there's so many factors that go into making that decision. Again, it's really a personal situation. It depends on where you are. If you're in foreclosure, that might speed up your process. If you need some money right away, that might speed up your process. If you're going to get lots of damages through Fair Credit Reporting Act, which you can go back 2 years from date of discovery, then you may just want to wait. It just depends on so many different factors. There's no one answer to that question.
And these calls are recorded. I believe these calls are recorded. Can I just log into the main website and download them from there? Or do I have to get somebody to forward me a link? Because I'm not sure how that works.
I am not sure how.
Send me an email, Mike, and I'll give you the way to get in.
Okay, I'll be glad to do that. I did that last week or the week before. I'm not sure which, and I just never heard back. Not to bust your chops. It's just I'm not sure. Maybe it just kind of slipped through the cracks.
I want you to bust. Sorry. All right, we got a bunch of people packing up here, guys.
Okay, then I'll let you go. Thanks, guys. Appreciate it.
Yeah, brother. God bless you, man.
Okay, our next caller with a question is D.
Hi, guys. Thanks a lot. Mine will be brief. First of all, I want to find out, is there a way to get the archives of the conference calls?
Do we want to give out that number over the air?
Oh, don't.
I don't really want to put it in an email.
Yeah,
okay, where do I send an email and I'll get that info?
Well, who notified you of the call tonight?
I'm a member.
Oh,
well,
you're not getting the info?
No. I get the info when there's going to be a conference call or a webinar, but no one's ever sent me anything as far as the...
Just shoot an email over to the webmaster in the morning or tonight, and I'll address that first thing tomorrow morning.
Okay, webmaster at... Okay, and what's the webmaster's address?
It's right there on the site. You remember.
Got it.
I like to give
I'll go there. Okay, here's my question. Basically, I have a situation where there was a credit card company suing me, Citibank, and it's an attorney, of course, a debt collector. What happened was they didn't serve me properly, so I filed a motion to vacate, and that was awarded. Somehow something happened where the
good job,
yes,
buddy.
I'm a member. Yeah. Something happened where I got a note saying they were going to have to reverse it because they didn't receive my payment, which I paid. So I'm in the process of suing my local clerk's office. But right now, there's a prove-up hearing where they have to prove up their claim, and I want to know what's the best way to handle what artillery should I bring in because I'm going to go to the hearing as well, and I'm representing myself. So I was wondering, what should I do to throw out their claims at the prove-up hearing because I've never gone to one.
Well, I thought the judgment was vacated.
Pardon me?
Maybe I missed something. I thought the judgment was vacated.
Yes, it was. But then what happened, I ended up getting several months later, somehow, some way, the clerk's office here in San Francisco said that they never got my payment. They lost it. And they never cashed my check, but I paid it. I had my receipt. So right now that's in dispute, and they're supposedly trying to work it out, but I'm suing them because of their negligence.
Wait a minute. D, you got to understand. You know what you're talking about, and you're talking with so many pronouns, we can't track you. Who is
Okay.
they?
Okay, yeah, let me clear. Okay. The clerk's office, my local clerk's office where I made my payment, they sent me a note saying that my motion to vacate, which was granted in July, they told me because they couldn't locate my payment that I made to file, that they were going to throw out my motion to vacate.
They can't do that.
Did they not give you an opportunity to make that payment, even if you didn't make the payment originally?
Exactly.
Oh, no, they didn't. They told me what I would have to do is pay the payment again and then go before a judge to see if I could have it reinstated. Now,
that's outrageous.
Yeah, and my dilemma is that the attorneys had received that motion to vacate, but as soon as they got the note that this was thrown out, they jumped on me, and they started, they came after me again, and now they have a prove-up hearing scheduled. Now, when I say they, the court has a prove-up hearing where the attorneys have to prove themselves, and that's tomorrow. And I was wondering, what should I bring?
If I may, let me ask you a couple of questions, Dave.
Yes.
Does the clerk take your filing without you having to pay for it?
No. I gave them a check, but they never cashed it.
No, but you have to give them a check in order for them to accept it, right?
Yes, that's true.
So, by de facto, they were paid. They lost
your
check.
Of course.
They lost your check. That's not your responsibility.
That's the first issue. The second one is if it's vacated, if they want to resume, they have to serve you all over again. You get a chance to answer and all this stuff. How could you jump to post-trial prove-up? How did that happen?
That blows me away because I don't know how they even managed it.
Well, you need to go and address it in a matter of the filing fee that was paid.
Well, you still have the same initial issue anyway of improper service.
That's right. Exactly.
Well, let's talk about the immediate situation, because if you got a hearing tomorrow, then you need to deal with that right away. Are there any witnesses that are going to be there, or do you know?
That I don't know. They may send one of their attorneys out.
Well, no. A witness from, who'd you say it was, Citi?
Yes, Citibank, yes.
Okay, how much is the alleged debt?
Well, wait a minute. Wait a hold it. He said the magic word, Citibank. You sure it's not Citi Credit that's suing you?
No, it's actually an attorney, but they're saying that they're representing Citibank, North Dakota, N.A.
Okay.
They're not. There's no competent fact witness, and they own the debt, guaranteed. Citibank's not involved.
Right.
They're just using their name.
Got it.
How much is the alleged debt?
The alleged debt is for $12,000 and some change.
Okay. Well, when you get there, you call a witness from Citibank, and if they don't have one, then you move to dismiss for lack of subject matter jurisdiction because they don't have any evidence whatsoever that you owe Citibank any money. And you can certainly bring up the fact that you believe that the alleged debt was bought by the attorney, and he's committing a fraud on the court. Did you have a court reporter there tomorrow?
They didn't tell me. They did not.
Well, you need to get one.
You need to get one.
Yeah. Absolutely essential. What time is your hearing?
It's at 1:30 tomorrow, Pacific Standard Time.
Okay, as soon as you get off the phone, do research on court reporters in your area, and first thing in the morning, 8 o'clock tomorrow, you call them up until you get one who can be at that hearing at 1:30.
Got it.
But check your local rules. They're probably online and in most courts, they don't provide court reporters. You got to do it yourself. But check and see if that's the case.
Okay.
And I would suggest, based on the current situation, put on the record that you're preparing a Fair Debt Collection Practices Act lawsuit against the attorney and the law firm and anybody else who's dealt with this case.
Okay.
But, I just have a question. You don't have a copy of the check that you paid the clerk even if you went and got certified funds?
They didn't cash it because they lost it.
They didn't cash it. They lost it. And many months later,
with sale, you can't walk in there and give them another cash or check.
Oh no, they told me that since they decided to throw it out, that what I would have to do is pay that plus an extra $80 to have it go before an attorney to see have it go before a judge to see if I could have it reinstated. They're really broke here.
Never heard of such a thing.
No. All that's wrong. No.
Yeah. They're broke. They're broke here. They're milking us left and right here, every way they can get us.
Yeah, and what they're doing is they're throwing his case out for their negligence.
Exactly.
And the clerk never would have accepted that filing without the payment. So where is it?
That's true. Exactly.
That's the question.
And they're telling me that
clerk would not have accepted my pleadings without the payment. So where is it?
Exactly.
Wow.
Oh, they're terrible out here.
Yeah.
Well, good for you for suing them.
So let them know that I'm going to be preparing a lawsuit against them.
Fog is not limited to the bay in that area.
Holy crap.
Yeah. Anyway, we need to move on, D.
Thanks, guys. I appreciate it.
Okay. Jim, you had a question?
Yes. This is Jim in Texas. I'm a member, and I got a quick question here. I've kind of go along with what Jesse said. I've got a new mortgage from Century, and then they turned it over to Carrington, and Carrington filed for foreclosure when I didn't pay them anymore. And and I read somewhere where the servicer does not have the authority to file for foreclosure.
Okay, you have to repeat that question.
I read somewhere that a servicer did not have the standing to file for foreclosure. Is there anything to that?
A lot of case history that says that, but that depends on state to state. And it really does, and it depends on how crooked the judge is.
Okay,
the problem that we're all having is, for instance, you get great case history going in Ohio. I can't use that case history here. I'm stuck with Florida case history. I can reference the judge. I can give him a copy of the decision so he can read it, but, it might influence him. It might not.
Yeah.
So, servicers, and I sent you guys out as the members the case decision that the servicers have no right to foreclose because they have no financial interest in the outcome of the litigation. No different than MERS.
Yeah.
So it's irrelevant to me if I foreclose or not on you as a servicer. What am I going to benefit from it?
Well, see, I sent that
me the money.
QW, that qualified written request out back in April of 2010, and the letter I got back from Carrington said CMS is not the originator of the above referenced loan. Therefore, all questions that pertain to the funding of your loan and bank account used would need to be directed to the originator.
Well, good. Did you send it to the originator?
Well, it did, and it came back said that address was no longer valid.
Well, you saved that. Remember what I said? When you sue him, the sheriff is going to say the same thing.
Yeah.
You got it?
Well, is that all on the website?
Of course.
Okay, I just need to get in because I've been working on the local attorney here filed for a summary judgment, and I'm filing to put a stop to that, and because I'm doing this pro se. And somewhere I read that of course, this lawyer's got 35 different reasons why that I don't have standing. See, I filed this the day before they had the foreclosure sale, and they went ahead and had the foreclosure sale, and it was a lawyer that came up out of Dallas to hold it, and so I'm heard somewhere, somebody told me that they could not obtain a summary judgment if I was doing this pro se.
That's not true.
No, remember I told you, I think you asked me that question a few weeks ago. Never heard of such a thing. Doesn't matter if you're pro se or not.
Okay. Well, I'm still filing to stop it. Can I ask for a summary judgment from them on the end of my paperwork?
Yeah, you can, but under what grounds? Don't do what he did.
Okay. Well, I guess I just need to go to the website and do a little more studying.
You got to listen to more of the webinars.
Okay.
and then watch the actual tutorials that are there.
Okay.
Because that's where all of it goes. Once again, you have to start from scratch. Step 1, step 2, step 3. You know what I mean?
Yeah.
All the way through. And once you get, you're going to feel better once you start understanding some of that stuff, and it'll all come together. And once it all comes together, man, you're done.
Okay.
You got them.
All right.
Make sense?
Thank you.
Thank you, Jim.
All right, buddy. God bless you. Have a great night, man.
Next up is Bobby.
Yeah, let me get to my question here. There was an article that I believe you sent out a while ago, like just in this last week or so. New York Supreme Court upholds MERS ability to foreclose. And then another one, of Alabama court says alleged problems with securitization aren't a borrower concern. And as I read those, my question was how those will affect my federal case and the ongoing process that I'm in. Since I found that MERS did assign my deed of trust to J.P. Morgan back in October of 2010.
Did they ever give you notice of that?
Well, I finally saw it filed at the.
Notice, Bobby, you're not answering the question.
I don't believe I ever got anything in the mail like that. The only thing I found, the way I found out about it, was just checking my county recorder, and I found it in there.
And when was it filed?
It was filed, I believe, let's see, 10/14/2010.
After the action was commenced?
I would have to go back and look at when the action actually started. Guys,
if you remember, that's one of the conditions precedent that's in our tutorials. I did a whole webinar, a real long one, on all the conditions precedent that they have to do. Now, that goes back to the premise that, you come in with a cause of action hoping to gain a cause of action. That doesn't work. That's a simple basis in law that I can't sue you and then come into the court with a reason to sue you and say, well, I didn't have a reason then, I just did it just because I wanted to, and now here's the reason, you see. You can't do that.
Yeah.
And 99% of all these foreclosure cases in Florida, that's how it works.
I never saw any. I haven't found an assignment to MERS anywhere.
How about an assignment to MERS?
That's what he said. He hasn't found one.
Okay.
Yeah. So there's not a clean chain of title there.
From Great Western to Washington Mutual, and then I never saw any other assignments until I found this.
And then Washington Mutual's out of business.
Yeah, well, J.P. Morgan took them over, and I was informed that that J.P. Morgan was going to take them over, and then I was informed that they did take them over. But I never saw any assignment to MERS, and I only recently found this assignment from MERS to J.P. Morgan. I guess it's because it was after I had originally looked at my my county recorder's records before this was assigned.
Yeah.
But anyway, I wanted to know how those cases may be affecting the MERS aspect of my
They're
case.
Not. Every state has different, like I said earlier, every state has different case law.
Do you know anything about Tennessee case law? And I haven't found anything that specifies Tennessee yet.
Yeah, and don't worry about it. You will set new case law. That's the whole goal.
Okay.
The whole goal is you're coming in there and saying, hey, listen, this is the way it's got to work, et cetera, et cetera. We encourage people to do that. It's just like what I found with the the FCRA and the collection of an account. Nobody's ever looked at the word and defined the word account. It's applicable only to bank accounts. So what are you doing on my credit report? That little discovery will start setting up new case that's good case law and get rid of the bad case law that's out there.
Mm-hmm.
You follow? Don't worry about what happened in New York and Tennessee. Concentrate in Tennessee.
Now,
Trust me, man, I read this. Now, what I do is, I remember what I tell all the students is glean the information from the bad decisions, because there's tons of good information there. But you got to learn to glean the good from the bad. Just like when there's good decisions, sometimes there's some bad information in there. And you go, what the hell was this judge thinking? I mean, he ruled in favor, great, got the job done, but it wasn't right. I've seen plenty of those cases. So it works both ways.
If I sue an attorney in federal court, how do I get the filing fee back?
You're going to get the filing fee at the end in your cost.
That would be in my costs?
Yep.
And if my case fails or is dismissed, am I liable for their court costs?
No.
Only if you file a frivolous lawsuit. In other words, basically you've lied about it or you just made something up completely. Otherwise, under FDCPA and FCRA, there's no way that they can get their court costs.
Can they be sued in small claims court just as easily, and what's the advantage or disadvantage in doing that versus federal court?
You're on your fourth question, and we got about 5 other people that got questions. It's already 9:06, so we got to get this thing popping.
I've got a webinar that covers the advantages and disadvantages of filing in federal versus state.
Right.
Okay.
There's only about 3 or 4 minutes worth of information there. I mean, it's pretty succinct, but it's too long to go into right now.
All right. Thank you.
You're welcome.
All righty, guys. Have a great night. God bless you. Bye.
Okay, we have, is it Aguirre?
Yes, sir. Hi, Dan. Jeff.
Right. Oh, it's
All right.
Carlos.
Yes, sir.
Oh, well, I got to change that name so that I can call you by first name.
Okay.
Go ahead,
yeah,
please.
It's Carlos, yes. Yes, I'm a new member. I've been a new member for about 2-3 days, and I do really like it. It's great. Congratulations. Good. I think it's great. A lot of info. I'm real happy with it. And also, Jesse, you spoke on the call where they invited you on Saturday. You said you had a way to get rid of the. I have an IRS notice of lien in one of my properties, which is attached to my Social Security, and they cannot sell that property. I have most of my properties in trust, which there's no problem. Only this one, I did not have it in trust. They attached that notice of lien to my Social Security. Whenever I try to go and close on that deal, IRS shows up and they bring down my whole process.
How old is the lien?
How old is the lien? It's probably about a year and a half.
Oh, okay. So it's a notice of lien. It's not a lien.
Well, in California, it's always a notice of lien.
No, in the whole entire United States.
Secretly.
It's applicable everywhere you go. It doesn't really matter.
Yep. Okay. Yeah.
My point is that all I ever do, a lien has to be recorded in public record. Okay? And here we go down to the comptroller's office and say, hey, where is the judge's order on this particular lien? And they're going to look and say, well, we don't have that. Well, what do you have? The notice of lien. Well, that's not a lien. That's a notice of lien or a notice of intent to lien. Where's the lien? And why is you falsely reporting it? See, that can go back to the FCRA too. You're falsely reporting information on my credit report. But you tell them, I need you to write me something saying, here, there is no judge order, signed judge's order. There was no due process to get this lien. There's no valid lien on file in public records. Go back to whoever's liening that, or you show that to your title agent if you want to sell the property or whatever you're going to do with it. Here you go. It's right from the comptrollers or the county recorders or whoever it is that's in. Every state handles it just a little different. But does that make sense?
Yes, it makes a lot of sense. The only problem out here in California, the IRS attaches it to your Social Security number. I sold
they do that everywhere.
house.
That's process.
I'm sorry?
That's standard process everywhere you go.
Okay. I sold that property to my son. He went and sold it, but at the end, they went back and they says, you cannot sell this property. And I told them, that property is not being sold by me. It's being sold by the person I sold it to, which is my son. I have nothing to do with it. He says, but you're still attached to it. So they kind of dropped everything. Title did not want to take a chance. Title company.
Yeah, well, all you got to do is go get the witness, which your witness is going to be the county, saying, hey, there's no valid lien on record here for this particular property.
If I could add something here.
And go check your credit report. Obviously, dispute the debt with the credit bureau, right? And this is added stuff you can do. You dispute it with the credit bureau, and then they're going to come back and say they verified it, and you're going to say, well, you couldn't have verified it because I have this right here from the public record, and now I'm going to sue the shit out of you, and you're going to pay me a bunch of money. How's that? So,
Okay.
I mean, there's a million ways to skin a cat. It's just how much trouble do you want to go to do it?
Hey, Jess, let me
Well,
ask something.
I'm willing to go to the trouble. I mean, I'm in the learning process. I've been going around a lot of places, and like I said, I congratulate you guys. Good website, and good luck.
But don't go through around to a lot of places, because all it does is confuse you. And what we have seen over years, I've been in this for a long time, and I have never fallen for anybody's junk. Never, ever, ever, because what I try to do is stick with one thing that I know works. You know,
yeah, well,
we're one of the few guys, and I think you can see that on our site, that we don't say, oh, I can't show you the proof. You know, that case was sealed. You know, I'll show you the proof. We don't beat around the bush. Here's the proof.
Hey, Jess.
Here's the checks, here's the judgments, here's everything. There's the proof. And that's the difference between us and everybody else out there.
Hey, can you guys hear me?
Yeah, I can hear you.
Okay, I was going to ask them if I could to the IRS question.
Yeah, go ahead, John. You're the expert on the IRS anyway.
Did this arise from not filing returns, or just that they said you owed more money?
No, this came up. I didn't file for 2 years. I didn't have those documents, and they says, well, you owe us this money. And I said,
did you file the
fine.
returns ultimately?
And then I didn't file. Then I filed, and they said I owed them $59,000. That's a lot of money. I'm not going to pay that.
Yeah, well, of course. Okay, so you filed. Okay, so you filed, and then there was, based on the returns you filed, was there a debt that you owed them based on what you filed?
No. Well, according to see, we went through a whole process. They did an audit on me.
Yeah.
They did an audit, and then I had to file. When I filed, they came up with the answer that you owe us $59,000.
That was from their audit. But what did you come up with as owed on your tax returns?
I don't recall the exact amount, but it was about
far less than what they said.
Yes, $22,000.
Okay. So, but by the fact that they got to a lien stage means you've gone beyond the 90-day letter, you've gone beyond tax court, you've gone through all the levy stages. They're not actually actively collecting it, but you could ask them for a proof of claim. Okay, and there's you can find out how to do this on their website. You just do a Google search, but the form you want to see that they're supposed to fill out is Form 4490. It's a proof of claim form, and this will show how they arrived at that number, which I don't know if that, what that's going to do, but there's another form that you need to get with this, and the IRS has this form, I can't remember the form number offhand, but basically it's a one-page form. It looks very unofficial, but it does have an OMB number, so it is an official government form. And on there it basically says that the lien is not necessary, notice of lien, is not necessary because the collection of the tax is not in jeopardy. The time that it would be in jeopardy, for example, would be if, let's say, you're a foreign citizen and you come here once in a while for business, all right, well, then that might be in jeopardy. But you live here, you're born here, or whatever. So if you fill out that form and file it with the IRS, there's a good chance they'll release the lien and just continue on with other collection methods like levies and so forth.
Okay.
Okay. The only other way to get that thing released, so you can get that property out of your name, possibly might be bankruptcy. That's a little complicated, but I would start with asking for the proof of claim and go on their website and find out. And I can dig it up if I can. Maybe on the next call I'll bring up the form number. The actual, I forget the name. It's like the release of lien because there's no jeopardy, something like that.
Okay.
And I'll share that with
you.
all.
Good deal. I'll remind you next week.
Okay.
Next week.
Okay, great. Bob, you're up.
Yes, good evening. Real quick, I settled some credit card debt for less than what I owed, and I just got a letter from the IRS saying I owe them $1,000 because they filed 1099s. Is there anything you can do about that?
Yeah, were you insolvent at the time? Did you have more debts than income, liability?
No, not really.
You were solvent?
Yeah, I was just paying them. What I did was I lost my job several years ago. I wanted to keep my mortgage up, so I paid my mortgage but used credit cards to pay bills and got to a point where I just couldn't handle it anymore, and that's when the interest rates went up. That's when, I started looking around.
$1,000? $1,000 claim they filed?
Well, the IRS says that I owe them $1,000 additional.
Okay,
Taxes,
so just
yeah.
so you understand the two rules here, and these are letter rulings, by the way. This is not some law, but this is how they published these letter rulings in the 90s. They basically said, you owe us a tax on imputed income, meaning the forgiveness of a portion of a debt. If you have a settlement agreement, number one, that you completed or didn't finish, or you were solvent at the time during that tax period. So if those are true, which it sounds like both are, then they would rightfully go ahead and collect. And so the only time I wouldn't volunteer it, but if they sent me a notice of deficiency, it makes sense to pay them, because the alternative is they're going to come back with some whopping fees, and they're just going to hit you real hard. It's going to come up to like $25,000 real fast.
Oh, okay.
So your first loss in this case is your least, and I'm telling you the two principles so you keep that in mind in the future. That's why I tell people don't volunteer to pay creditors, because they will get all their money. Even if they accept half from you, they're going to get the other half from the taxpayers, and you're going to pay a tax on it. So just keep that in mind.
Plus I paid 15% to a lady that resolved all of this and never told me.
She should have set it up properly. There was a way to plan it out to where you would not have that liability, but she didn't consider that, and a lot of people don't tell you that. But there is a way to plan it so that you're not liable for it.
And John, I think you coined this phrase that debt consolidation companies and bankruptcies are nothing but other forms of or other names for payment plans.
Right.
Okay, and you never win in the end.
Yeah, really.
You're better off not paying anybody. Because here's your debt consolidation. You said, I paid her 15%. So add 15% of whatever it was that you paid. And generally, when you're done with the fees, the monthly membership, all the other stuff with these debt collection people, or debt settlement people, you're paying 106, 115% of the actual NAM debt. And then on top of that, you get a tax consequence. But I suggest that you talk to a good CPA. Have you filed your taxes for this year yet?
No, that's why I was holding off.
You might be able to You might be able to do your returns with a person who understands the imputed income tax, a real competent one. But if you've already filed, keep this in mind. If you've already filed and you're in this situation, you can amend your returns 3 years out. Right? So that's not a problem.
Take a loss, because I know your house has probably lost money like everybody else's, and be done with it.
Right.
Yep, there you go. So
I just helped a buddy out. I helped a buddy up in Jersey. As a matter of fact, his house dropped $100,000, and the IRS says, hey, we're going to penalize you $23,000 because you took some retirement money early. Oh, no problem. My house lost $100,000.
Yeah. So if you have a deal like that,
it doesn't really matter.
Okay.
Yeah.
All right.
And if the $1,000 is a hardship, you can do an offer in compromise, Form 656, and they'll reduce the amount based on doubt as to collectability. That's probably not true in your case, though. Yeah.
All right.
So
well, I'm unemployed again and trying to save my house, so I've got issues. But just one other quick question. Last week you said that in 48 hours you were going to come out with something that was really going to be dramatic and great, and I didn't see anything on the website. I am a member.
I've been waiting. You'll get to I worked on it all day today. My father-in-law had a stroke, so I'm trying to keep up with all the stuff here. But, I actually gave that to Gary today.
Good. Great. I was just curious as to what it was. All right, great.
I got a couple things I'm working on.
Okay, Belinda, you're up.
Yes, I'm ready. I really have about 3 issues, but I want to ask a couple of questions, please. I have a MasterCard that has a balance of only $251, and someone called me from the MasterCard office and said, well, we want you to pay this. I said, well, I don't have any money. Well, can we send it out for a little time and then you agree to pay it, and we'll use your account number that you paid with before? I said, well, I don't want to do that. But in the meantime, the call was being recorded. So I told her, I said, I don't want to do that. I said, you should not have the ability to retrieve my payment information from a month ago. And anyway, they did it. They sent me a confirmation letter that they were going to deduct it from my checking account because I had paid with that before. And so I want to sue them, and I want to find out if I have the ability to sue them for taking my money out of my checking account without my authorization.
Is it the credit card company itself that called you?
No. Yes, it is. It's a MasterCard from a company called Emblem out of Atlanta, Georgia.
Okay. And you're fairly confident it was Emblem that actually called you to try to get your payment?
Well, they said, well, this is card services. They were calling on their behalf.
Okay. Do you still have that phone number?
I do.
Okay, call it back even tonight and see what picks up. I mean, it could be the credit card company or it could be a collection agency. When they took the money out last time, did it show as being the credit card company that took the money out?
Well, I'll look on my bank statement and see. But someone from there called me when I told them, I said, well, I am going to sue you because you should not have the ability to retrieve my payment information. I say it's a lot of people that work in your company that are not honest. I said once a payment is made, it should go in a place where it's not retrievable. And I mean, that's the way
I don't see any reason they can't hold on to the information, but they certainly cannot take any more money out of your bank account without your permission. Now, if it's the original creditor, you cannot sue them. Well, you can sue them under FDCPA, but they're going to allege that they were the original creditor, so that suit might not last long. The only thing I can think of is to sue them for breach of contract and possibly breach of fiduciary duty. John or Jesse, you have any other ideas on that?
No, I would definitely sue them. You're right on the money. You're absolutely right on the money.
Okay,
I think you're probably talking about a state lawsuit.
They're going to die when you hit them with a $10,000 lawsuit.
Well, I told her, well, the lady did call me. I said, I'm so happy that you recorded this call. I said, because I told her don't do this. And it was done anyway, and you have sent me a letter of confirmation that you were going to do it. And surely enough, they did deduct the $36.39 from my checking account on April 11th. And then this lady, Teresa, called me from their office, and I was not here. So I spoke with Angie, and I told her everything I just told you. So she asked me, she says, well, are you going to be home tomorrow? I said, yeah. And they've called since I've been listening to your call, and I did not pick up.
Okay. Now they're probably going to make the claim that at some point you gave them permission to take that money out of your bank account, but there's no way that they can prove that. So I think from what I'm hearing, your best bet is to sue them in state court for definitely violation, well, breach of contract. I'm trying to think of what other causes of action you might have.
You said breach of judiciary something, but I didn't.
Fiduciary duty, basically they have access to your money, so they have a special obligation to treat you with respect. I don't know if that particular claim is going to go very far, but you can certainly try it. But look up fiduciary duty and see if you think it might apply. I think I would sue them for theft, for conversion. Yep. They stole your money.
Oh, that's good. That's good. Okay, and I do have one other question.
I didn't even go as far as to call the police department and file a report.
Call the police
just to memorialize it, show them the
statement. That's a good idea. The police department is probably not going to do anything, but it shows that you really took this seriously.
Yeah, do that and then file a report of theft into your account with the bank too.
Oh yes.
Okay. All right, then that's great. Okay, and I have one other question. About 15 years ago, I had a problem. And I had theft. My husband, I'm a widow, and my husband had passed away, and I had some money. And someone stole the money from me. And as a result of that, when I got ready to do my taxes like a couple of years later, I talked to my tax attorney about it and all that. And it was proved fraudulent on the state level because they were withholding my income tax refunds every year up until this date. But after going before the judge on the state level, I get my state, but the IRS has me owing them $25,000 as a result of that. And last year, for 2009 and 2008, I owed them about $700 that I was not able to pay. And they had sent a letter and I did an automated deal that I would try to pay them within a certain length of time, and so they picked up that debt from 1996 for the $25,000.
They can't. It's gone already. There's a 10-year statute of limitations on that. It's history.
Well, that's what I thought too, and so when I talked to her a couple of days ago, she told me, because it's on my credit report and everything, so every year they've been withholding my federal. And I just need to know, what can I do about that?
Okay. Jesse, I think this is a road we don't want to go down.
No, really don't. But I'm telling you, there's a statute of limitations. Do your homework on it.
Okay, statute of limitations. Okay.
Yep.
All right then. And as soon as I get some money for my $99 and then my monthly fee, I'm going to become a member. But right now, I just don't have any money.
Well, Belinda?
Mm-hmm.
On the front page of the website, there is a program that you can use that's free that you can use to raise the money.
Okay, then. That sounds great. And I have the website. It's freeandclear.net.
Yes.
That is
Don't
correct.
talk about website names on the phone, please.
Oh, I'm sorry. I'm so sorry.
That's okay.
Okay.
No worries.
We'll forgive you, Belinda.
God bless you. You have a good night. Let's move on to the next question. It's 9:30 already.
Okay.
Okay. Thank you much.
All right, sweetie.
Rainey, you're up.
Hi, how are you?
Okay.
Okay, this is what happened. CAS LLC is supposed to be the assignee from Tetris that become part of ASPC. However, they had a judgment on me since the 10/09. I never received the summons or the complaint because every paper that I have in the court has the address, my address wrong. And that includes the summons, the affidavits of service, affidavits of mail, and anything else that had to put my home address is wrong. I went to the transfer hearing last week, but the civil court judge wasn't very helpful. He is going to make a decision. Now, regarding the information I have from this judgment, where my address is wrong everywhere, should I start planning or suing them for any violation of the FDCPA?
I don't know your situation. I don't know exactly what it is. If it did improper service, there's no statute of limitations on vacating that for that. It's not a problem. The rest, I don't know.
So I should wait until the judgment said vacate and then plan to do something with the FRCA and the other.
Yeah, the FDCPA. Yeah. Yeah, you can. You always have alternatives with the FDCPA. Always have remedy there. And FCRA, because they violated something. We promise you there's no way around it. Like Larry said, they called you
last question.
Letter.
The last question is this. Yeah. How should I put my dispute with the credit report? I'm looking at the credit report, and this company have date assigned. That is April 2008. Should I take that like the first day they start reporting everything wrong about my home address? Or should I ask the dispute, should I ask the credit report to send me something in writing when they start to report my address wrong?
That's for you, Larry.
Okay, I'm not clear on the question. You're concerned they're reporting your address wrong?
Okay, no, everything on the judgment on the core folder.
Yeah.
From the affidavits of services, affidavits of mail, the summons, and everything else what they have to put my home address is wrong.
Okay.
Now, and I assume if you have a problem with this judge, I have to appeal. And I'm more than positive I will win the appeal. My question is this. Now I plan to ask with the dispute with the different credit reports when this company start reporting information wrong. So to verify it. And I'm looking, for instance, Equifax, they have something called date assigned. and the first day appeared 4/2008. I called by phone, and the Equifax people told me that is the best date they start reporting information to us.
Okay. Well, normally it doesn't really matter when they started reporting, even if it's inaccurate, until you have disputed with the credit bureaus. So you've done that, correct?
With this creditor note, I know this is a silly question. What should be the question on the dispute letter regarding to have information from the credit report? Because in the credit report appear date assigned, and I called them. They said the first day that they start reporting. But how do I put in writing so they can, send me a response in writing about this dispute?
Okay. Well, my preferred way of doing it is the first time you dispute with the credit bureaus is don't give a reason for the dispute. Just dispute anything that's negative that could be construed as inaccurate in any way, but just say, I'm disputing the following items and see what happens. Sometimes the stuff will fall right off, and no matter what they do, it's good for you. Either the negative items are going to drop off or they're going to remain there, and they're going to be in dispute status, which means that they're not really counting against your credit score, or they're going to remain there without a dispute status, in which case you definitely have a cause of action. But until you've sent the credit bureaus that first dispute letter, you have no cause of action for the accounts on your credit report. So it really doesn't matter what they can report anything they want, no matter how inaccurate or how outrageous. Until you've disputed it, you have no cause of action.
So
once you start disputing it, if it's still there, and as Jesse said before, you don't have to send another dispute letter. But if you want to get that stuff off, or if you want to really help your case, then start providing them reasons for why that account should be corrected or removed entirely. Whether it's the date or the address or the amount or whatever. Does that answer your question?
So to be sure, so when they answer me and I find the address is wrong, still I have to wait for the judgment to be vacated to take them to court using the FCRA?
FCRA. Well, they're not going to. The credit bureau isn't going to give you detailed information on that particular account. They're going to say it's either accurate or inaccurate, or they're going to remove it.
Okay. So at what point I then dispute the address of the report?
Well, my suggestion is that if you dispute it once and the negative item doesn't come off, because obviously this is a negative item, ideally you want it off, or you want to use it to build a case under FCRA. So, like I said, I would send the first letter just very generic. I'm disputing this account. Don't give a reason. And if it's still there, they come back in 30 days and it's still there, then you can start providing specific reasons. The address is wrong, the date is wrong, the amount is wrong, not my account, whatever it may be.
Thank you.
Okay?
I appreciate it.
Sure. Yeah, just remember, this is extremely important. You cannot create a cause of action until after you've disputed with the credit bureaus, not with the furnisher of information. It's got to be Equifax, Experian, or TransUnion that you're disputing it with.
Oh, you should remind me, my last question. What about the collection agency that basically create this document with the address wrong? Can I sue them too in the future?
You can always sue collection agencies. I've never seen a situation where a collection agency couldn't be sued. And if they're on your credit report and you've disputed with the credit bureaus, you can sue them for FCRA and FDCPA.
As a matter of fact, I'm just looking at Equifax. The credit report, this is Daniels and whatever. It has the same address as the so-called, creditor.
Mm-hmm.
And
really?
The same office.
The collection agency has the same address as the original creditor?
Yes.
Yeah, that's interesting, huh?
The report.
Yeah. I think, I recommend you sue everybody you think could possibly have violated the law and let them sort it out.
Okay. Thank you.
But you got to set them up properly. You got to go through a step-by-step process.
Okay, I appreciate it.
Sure, no problem.
Hey, Jeff, how many questions are left?
Three. I'm sorry, I had myself muted so you wouldn't hear my heavy breathing.
All right, that's it. The last three questions. So no more raised hands, guys.
Alfonso, you're up. Alfonso.
Hello.
Hello.
Hi, can you hear me?
Barely.
Yeah, I can hear you.
Your question is?
Hang on for a second. I'm not hearing you very clearly. Hello?
We hear you.
I think I have to pass because I can't hear you very well. Hang on. Something wrong with my line.
Then call back in.
Yeah, I'll have to pass this time. My line is not very good.
All right, go to the next one, Jeff.
All right. Harold, you're up.
Hey, guys. Just want to...
Harold.
All right.
Hey, Harold, by the way, thanks for the emails, man. I appreciate when the members are sharing information that we can repost with other members. So I appreciate you taking the time and thinking of us that way, man.
Okay, and we got to get in contact soon. Okay, just quick few things regarding some of the callers that had called in. With regards to the guy who spoke about servicers not being able to foreclose, if he looks at CFR, 12 CFR 226.39A1, that kind of like knocks them right out the box. They can never go in as the holder or owner of a note at any time as a servicer. So that basically addresses his question that he had. The guy who talked about no assignment to MERS, he's onto a big issue there because based on that bankruptcy case out of New York, it made it clear because that decision is a very monumental decision because it was the first decision in the country that actually, according to Professor Ray out of the University of Kansas, he says it's the first decision that ever examined MERS business practice, and it declared them, for the most part, illegal and absurd.
Yeah, straw man. There's no good. And actually,
now the issue with MERS on the mortgage or deed of trust or grant deed, where that comes into effect is that if the lender had never given you written notice of MERS assignment into the deed of trust, mortgage or grant deed, that's a problem because if they never got official in writing positioning on the mortgage, it's void.
That's right.
So that's a key issue that guy was on because that's something I'm working up right now myself. Okay, the lady who had the issue with the people taking money out of her account, y'all gave great advice on that. And I would also have her to consider sending in a letter of objection, as well as make that police report. That was very good because what you want to do is always rebut the presumption of regularity. And when you file complaints and make objections, you automatically rebut the presumption of regularity. So if it does go to court, you come at least on, a level playing field. But if you go in as plaintiff, as you guys advocate, that one-up you over them. That's all I got for now.
Thank you.
Harold, thanks for the contribution. That's exactly what we want. Our community to grow and with each other working, not giving BS advice out there or crap that don't work. That's exactly what the entire site's been set up to do via the forum.
No, I don't deal with stuff that don't work.
No, man, and there's too much of that out there. We all know that. And, it's stuff that we need to share together in the forum, help each other in the forum. This is exactly. I consider it the Facebook of foreclosure and debt collection. And that's the way it should be. Everybody needs to share, post their successes, their losses, their questions, their concerns, because that's how
Do we have 500 million members yet? I didn't know that.
Yeah.
We're working there. We're getting there.
Cool.
But
well, in
this is
actuality,
really
what I want to talk to you about is, to join forces with that so we can actually create that network where you have different thoughts out there, non-competing, but everybody is under an umbrella so they can be in like a shopping mall of ideas regarding things that do work.
That's concept of it, and that's a great thing, and we love to hear the motivation that you have in your spirit, and a lot of the members do, and that's a great thing. It's an awesome thing because that's how we're going to work together. We all know that none of us here tonight has said anything that's out of line, that sounds outlandish, that's going to wind somebody up in jail or make you lose in court, make you lose your home, make you lose your car, your family, whatever it is. We try to keep it on the up and up. This works. Here's the proof. And that is something that we're very strict about. And I really enjoy when we hear other members chime in and say, yeah, you can do this, do that, do the other, because these are other ideas that have worked for other people. We never claim to be a guru. I don't want to be called a guru. We've just, my head hurts, man. I've been beat, and Larry's been beat, and John's been beat about the head with a billy club for a lot of years, and we've learned the hard way. But, for the last few years, the hard way has been what saved us, and that's why we've won every case, because we've went through the nonsense of losing and getting laughed at and whatever the case may be. But now it's to the point where we know it, and there's nobody going to take that from us. And that's just the way it is. And we know it's going to work. And that's why we encourage the members, do the research, do the homework. It's all right there on the site. I can't keep putting up more information, guys. We cannot. I want to do more tutorials. I have so much information sitting on my computer as we speak that Gary's got to put up that I'm telling him just hold off on it. Because I try to look up news every day, maybe some few good rulings. Harold sends stuff. Jeff sends stuff. We have other members that send me stuff every day, which is fantastic for news to share with the other members. But there's got to be a limit because you just cannot handle so much. It's just overburdening mentally. And everybody's tired, man. Everybody's been in this fight for a long time. And I know there's some people that are just coming around, but I'm telling you, man, this stuff has been around for a long time. And it's an ongoing battle. And we try to make the battle short and sweet. We win, have a good day, versus this long, drawn-out nonsense.
Okay, we got two more questions here, Jesse.
No more. We quit it at third. So that was it. Unless Larry, John, you want to grab them, I'm out of here. I got to get some rest, man. I've been running all day long.
Okay, we got somebody else that's calling in. It looks like their employment phone number, area code 336.
Larry, you got it?
No.
Yeah, as long as they're quick,
Yeah, it's quick.
We really wanted to wrap up after an hour or so, but let's go ahead quickly to the next couple of questions.
Okay. I'm ineffective.
And remember, everybody, we do these every week, so if you don't get your question answered this week, just ask it next week.
I received an order for default judgment. The credit card company did not respond. This was March 31st. The order was entered. Today, I received a call from an attorney representing this credit card company asking me would I dismiss the case. So I looked on Pacer. They haven't placed a notice of appearance or anything. Once that default judgment is entered, do I have to worry about them? Being able to come into the case or anything?
Did you get a default, or did you get a default judgment?
Default judgment.
You sure about that?
Default judgment.
Okay, this shows the importance of describing your situation very precisely. You filed a lawsuit in federal court against a what? Debt collector?
Yeah,
I'm asking you.
Company.
A credit card. Okay. All right. Yeah. All right. So you served them properly, correct?
Yes.
They did not respond within 21 days, correct?
Yes.
Okay. They didn't respond with anything. All right. So you filed a a default with the clerk of the court. Is that correct?
Yes. Yes.
Okay. All right. So you've gotten contacted by an attorney who has not appeared in the case.
Yes.
How long ago did you get the default judgment?
It was entered March 31st.
March 31st. So it was less than 2 weeks ago, correct?
Yes.
All right. Here's what I would do, because the longer they wait to try to vacate this default judgment, if they filed something now, there's a good chance, a very good chance, that the court is going to grant their motion to vacate the default judgment. I've gotten a few default judgments, and every time that the other side has given some lame excuse for it, the court has granted it, and you can just expect that. I would try to delay the case as long as possible. Ask them, say you'll consider it, maybe talk settlement, just play it out for a while. The longer they wait, if it goes beyond 30 days, there's an excellent chance that your default is going to stick. But meanwhile, I would certainly try to negotiate a settlement. How much are you looking for?
It's my claim was 6 figures, but I was just looking to get my credit report cleared off.
Okay. Well, how did you arrive at 6 figures? Is that just a number you like, or do you have those actual damages or statutory damages?
Actually, I did it $1,000 per day, and that's how long they've been in my credit report.
Okay. Yeah, Jesse had a theory once that you could do it per day, and I said, well, why not do it per hour? Why not do it per minute? Why not do it per second? And that's not going to fly. It's every time they report something inaccurate after you've disputed it, and you did dispute it with the credit bureaus, right?
Yeah.
Okay. It's every time they report it. Anytime they've taken any action that violates FCRA, you've got damages. So how many months does it go back where you first disputed and they kept reporting inaccurate information?
Last year, August, actually. I started in August.
August of last year? Okay, and it's all 3 credit reports?
Yes.
Okay. You're looking at about $25,000, maybe $30,000 in potential damages. So I would start with that number. Tell them, do you sue them just for FCRA, or are there FDCPA violations too?
FCRA and FDPA, yeah, both.
Okay. Well, either way, unless you have actual damages, you're only going to get $1,000 for FDCPA. Based on what you're telling me, and keep in mind this is very cursory, but it looks like you're looking at about $30,000 in potential damages. So you might start around that number, see if they're willing to settle for that, but drag it out as long as you can.
Okay. Thanks for your time.
And keep in mind, if you win this case, you can sue the credit bureaus too for the same thing.
Really?
Yep.
I was wondering if I heard somebody talking about suing an attorney. Is this one of them situations where I could add or go back and sue the attorney?
There's 2 ways you can sue the attorney if they're defending, and I've done it once, and Jesse's done the other one once. That is, if they send you something that says that this is from a debt collector, an attempt to collect the debt, and I've seen them do this, and I've sued them for it, and they're incredibly stupid, but I'll sue them if they're incredibly stupid. I don't care, as long as they have a viable cause of action. The other way is if they pull your credit, you can sue them for FCRA. Otherwise, you're not going to have a cause of action against attorneys defending.
Okay.
Now, if they try to collect money from you, well, I don't want to get into it, but unless they're really trying to collect, or you can actually pinpoint a violation, then I wouldn't worry about that aspect of it.
All right, man. Thanks a lot.
Okay, you bet.
Okay, our last question is coming from area code 501, and I do not have a first name for you.
Hi, this is Eloisa.
Say it again, please.
Eloisa.
Your question is?
My question is, I signed up for the program probably a month ago or 2 months ago, but and I've been through the website trying to see information, but how can I I don't know how to draw a lawsuit or what causes an action that will be, or how to drive a letter demanding some information from the creditors or from a foreclosure, like lender that being foreclosed. How can I? Don't you guys have on the website like already like a lawsuit just to enter the personal information, like account number, name, address, stuff like that?
You mean a template of a lawsuit?
I don't know how to. Basically, the question is I don't know how to use your program because when I go into the website, it's samples of other people that have been suing the creditors or lenders, but the information that they had over there is different than mine, or causes and actions are different than mine. So how can I know the cause of action or how to draw a lawsuit?
Well, I mean, to be honest, that's where you have to take responsibility and go through the information that's there, and you may have to do some additional research. You may have to read parts of FDCPA or FCRA, but you have to determine what your particular situation is. There's no possible way that we can anticipate every conceivable situation out there and have a template. We've got samples that you can adapt, and you just have to describe your particular situation in the lawsuit under the factual allegations, and then you have to match it up with any, the portions of the federal or state laws that they violated. But, for a call like this, that's all I can tell you. If you come on the webinar, you can ask more specific questions, or if you go to the forum, you can ask more specific questions. But, with this kind of a program, people, again, just have to be able to do the research and be able to analyze their particular situation. We could, at least in theory, spend 5 or 10 hours with you and draft a lawsuit for you and run you through the entire, process of federal court or whatever. But that's just not what we do. We just can't possibly have enough time to help everybody to that extent individually. But use the resources, but you have to use them. And we definitely want to help you to the best of our ability, but you have to, go through the website and pick and choose what's applicable to you.
Okay.
Does that make sense?
Yeah, I just still don't know what to start. I go like say my house or pay them or have them pay, and still kind of confusing. Well,
and honestly, some people make it more confusing than it needs to be. Simplify it as much as you can. What are your immediate goals? And you don't have to answer that question, but determine if you've got an urgent situation, or if you just want to make some few $1,000 on the side, or if you want to clean up your credit report, and then start there and take it step by step. You don't have to, you don't have to swallow the whole apple at one time. Just take one bite until you figured out exactly what's going to be helpful in your situation.
I guess I keep attending to that webinar, and I go from there.
Okay, but use the resources, use the webinar and the forum, please.
Okay, thank you.
Okay.
And the one thing about using the forum is it will help you get a clearer picture of what it is that you're going to need to do by correctly formulating your question.
Okay.
And one of the things that's really, I stress with a lot of people is to sit down and write out their current situation, but to do it in bullet points so that they remove the story and just have the facts and the essence of what has transpired or what the situation is. And by doing that, they get a clearer picture of what needs to be done.
Yes, that's good advice.
Thank you.
You're welcome.
You bet.
All right, that's the last of the questions.
Very good. Thanks, everybody.